Imagine you're scrolling through your feed, looking for substance beyond the usual flash-in-the-pan headlines when you stumble on a channel that's determined to separate fact from spin. That's us, NewsDecoded, where clarity is our calling card and critical thinking is the house style. If that sounds like the kind of journalism you want more of in your life, go ahead and tap the subscribe button, add a quick thumbs up, and leave a comment telling us what stories matter to you. Your engagement is the oxygen that keeps in-depth reporting alive, and it empowers us to keep cutting through the noise day after day. Now, settle in, because we're about to unpack today's legal and political whirlwind in a way that spans the full arc of the story. No shortcuts, no stone left unturned. The Justice Department has stirred fresh controversy by signaling interest in possible charges against former FBI Director James Comey and former CIA Director John Brennan. If that sentence feels like déjà vu, you're not alone. The same names headlined political firestorms back in 2017, 2018, and 2019, when allegations that federal investigators had politicized the Trump-Russia inquiry dominated cable news. At first glance, the new overture looks like an attempt to resurrect claims that multiple high-level investigations have already sifted through and dismissed as baseless. To understand why legal analysts from across the ideological spectrum say the latest threat holds virtually no weight in court, we need to rewind to the investigations that have already scrutinized every email, interview, and procedural memo involved. Enter Special Counsel John Durham, appointed in 2019 by then-Attorney General Bill Barr. Durham was tasked with determining whether the FBI's Crossfire Hurricane probe, launched in mid-2016 to explore ties between Russian operatives and the Trump campaign, had been tainted by political bias. Over nearly 4 years, Durham issued subpoenas, impaneled grand juries, and reviewed millions of pages of documents. His final report, delivered in 2023, cost taxpayers more than $6 million, but essentially yielded a single criminal conviction, an FBI attorney who altered a surveillance-related email and later pleaded guilty to making a false statement. 2 other cases Durham brought went to trial and resulted in acquittals. Crucially, Durham did not accuse Comey or Brennan of wrongdoing, nor did he recommend charges against them. On the contrary, his narrative described institutional missteps, but stopped well short of asserting that top leadership had orchestrated a witch hunt. Separate from Durham's work, the Senate Intelligence Committee, led at the time by then-acting chair Marco Rubio, embarked on its own exhaustive review. The committee's bipartisan report ran more than 1,000 pages and echoed a conclusion similar to Durham's. Investigators had found no evidence that political preferences distorted the intelligence community's findings. Rubio summarized the sentiment bluntly. Every witness interviewed said they saw no attempt to politicize the case. In legislative language, that's as strong an exoneration as one is likely to find. Fast forward to today, and any new indictment would have to overcome a mountain of already public exculpatory material, not to mention the practical hurdle of persuading a jury that earlier bipartisan inquiries somehow missed a smoking gun. So, why resurface the narrative now? One theory points to the controversy surrounding the still unreleased Epstein document cache. Earlier this year, former Florida Attorney General Pam Bondi stated that files purportedly naming associates of the late financier Jeffrey Epstein were right on my desk and poised for release. That same week, attorney Alina Habba went on a primetime talk show insisting the revelation would be, cataclysmic. Conservative pundits from Kash Patel to Dan Bongino fanned expectations that a bombshell list of familiar names was imminent. When the promised disclosure failed to materialize, outrage within those circles reached a boil. Cue the Justice Department's sudden pivot to Comey and Brennan, figures who long ago became reliable lightning rods for partisan frustration. The timing has prompted some observers to label the new overture a distraction strategy, a legal red herring designed to redirect outrage away from the fizzled Epstein reveal. Adding to the intrigue is the social media spotlight wielded by tech magnate Elon Musk, who posted that Donald Trump's own name appears in the sealed Epstein records. Whether Musk possesses definitive knowledge or merely amplified rumor, the claim landed with a thud loud enough to invite legal retaliation if it were demonstrably false. Yet no defamation suit has emerged from the former president. In legal circles, the absence of pushback often speaks volumes. Seasoned litigants seldom let reputational attacks slide if they have ready evidence to refute them. The silence from Mar-a-Lago has only intensified speculation that the Epstein file saga and the renewed Comey Brennan flap are, well, two prongs of a single political gambit. Divert attention by reigniting grievances against established foes. That strategy fits a broader pattern. Over the years, Donald Trump has floated public threats of prosecution against an eclectic roster of perceived adversaries: Special Counsel Jack Smith, New York Attorney General Letitia James, Manhattan District Attorney Alvin Bragg, former Representatives Liz Cheney and Adam Kinzinger, whistleblower Miles Taylor, and cybersecurity official Christopher Krebs, to name just a handful. Add Hillary Clinton, Gretchen Whitmer, and even segments of the press, and the list grows unwieldy. Yet, despite fiery rhetoric, few of these supposed cases have advanced beyond press releases or social media broadsides. For legal analysts, the result is almost mathematical. The louder the promise, the slimmer the likelihood of follow-through. Far from being a sign of escalating power, the pattern underscores just how difficult it is to bend America's decentralized justice system into a personal cudgel. Still, the psychological toll on targets can be profound. Being threatened with indictment, even implausibly, forces individuals to hire counsel, preserve extensive records, and endure public vilification. While civil defendants can counter-sue for malicious prosecution, criminal matters raise steeper barriers. Prosecutors generally enjoy immunity for actions taken within their official duties. Yet legal scholars argue that an unmistakably vindictive prosecution could breach constitutional protections, particularly under the Equal Protection Clause. In theory, someone like Comey or Brennan could seek damages if they proved the government singled them out for reasons unrelated to legitimate law enforcement objectives. In practice, however, such suits are uphill battles, and the individuals involved may prefer to avoid escalating the spectacle in civil court, especially when prior investigations have already served as de facto vindication. Even if charges never materialize, simply tasking federal attorneys with re-reviewing dormant allegations drains institutional resources. The Justice Department is no monolith. It houses specialized divisions ranging from national security to civil rights. Each new high-profile assignment siphons lawyers, investigators, and paralegals away from existing workloads. Critics warn that resurrecting an already litigated matter resembles rearranging deck chairs while pressing national concerns, cyber intrusions, fentanyl trafficking, extremist violence, demand immediate attention. The DOJ talent pool is finite, and morale reportedly suffered in recent years as seasoned prosecutors departed rather than risk association with partisan crusades. An exodus of expertise leaves narrower shoulders to bear heavy caseloads, amplifying the opportunity cost of crowd-pleasing but legally hollow ventures. That talent drain also erodes ethical guardrails. When career attorneys bow out, vacancies can be filled by less experienced hires or by loyalists whose primary credential is ideological alignment. The substitution imperils both legal rigor and public trust. Consider the Civil Rights Division, historically tasked with enforcing the Voting Rights Act. A pivot from safeguarding access to the ballot toward rationalizing barriers like stringent ID requirements is more than procedural drift. It is a transformation of mission. Lawyers who entered public service to uphold equal protection may find themselves asked to justify policies that undercut it. The cognitive dissonance is untenable for many, prompting resignation and creating a feedback loop. Each departure weakens institutional memory, making it easier for future directives to depart further from precedent. Peel back the politics, and the underlying clash is about the integrity of democratic institutions. A Justice Department weaponized to punish critics or settle scores undermines separation of powers, corrodes the concept of blind justice, and honestly, signals to future administrations that the guardrails are optional. Constitutional scholars point out that the framers distributed prosecutorial power precisely to avoid monarch-style retribution. When leaders blur the line between public interest and personal grievance, they invite judicial rebuke. Federal courts have historically rejected attempts to stretch statutes for partisan ends, often issuing stinging opinions that reaffirm prosecutorial discretion must be rooted in evidence, not vendetta. Every time a court throws out such a case, it chips away at the veneer of infallibility surrounding executive impulses. Yet the process consumes time and tax dollars that could be better spent. There is also a broader diplomatic cost. Allies monitor how the United States treats dissent and due process norms. When they see investigations apparently launched to appease a political base or distract from unrelated embarrassment, it complicates America's ability to champion rule of law abroad. Foreign leaders facing corruption probes in their own courts seize on U.S. inconsistencies to argue that prosecutions everywhere are political. In this chess match of credibility, each handicap we place on our own justice system is a gift to authoritarian narratives abroad. Conversely, every instance where courts, journalists, and civic groups hold power to account reinforces democratic resilience. For everyday citizens, these legal tussles may feel distant, yet the ripple effects are tangible. When DOJ bandwidth is diverted to show trials, legitimate cases, ranging from identity theft rings to Medicare fraud, can languish. Victims wait longer for restitution, and dangerous actors stay on the streets while prosecutors juggle politically mandated files. The notion that government can chase every phantom simultaneously is a myth. Law enforcement operates on triage. Resource allocation reflects priorities, and those priorities reveal values. Insisting on evidence-based prosecutions isn't merely an academic stance, it's a demand that Justice Departments nationwide focus on threats that actually jeopardize public safety. Against that backdrop, civil society's response becomes pivotal. Whistleblowers within agencies, non-governmental organizations tracking court dockets, academics dissecting legal documents in real time, all contribute to a shared defense against institutional capture. The same is true for independent journalism. By digging beneath press releases and televised soundbites, reporters illuminate facts too nuanced for partisan slogans. When audiences demand rigor over rhetoric, it shifts incentives. Politicians soon learn that hollow claims will be cross-examined in public view, reducing the payoff of theatrics. Every viewer who asks for sourcing, context, and data pushes the needle closer to accountability. Here at NewsDecoded, we embrace that mission. Our editorial credo is that complexity can be explained without condescension, and that transparency is non-negotiable. We won't pretend legal diagrams are thrilling cinema, but we will translate them into clear, engaging narratives. That means detailing how subpoenas work, why standards of evidence differ between grand juries and trial courts, and what constitutional safeguards look like in practice. We believe audiences are hungry for that level of depth, and tonight's story is a prime example. It isn't simply about who might or might not end up in handcuffs. It's about the architecture that determines whether charges even make sense. If the Justice Department insists on revisiting the Comey Brennan question, the procedural path is already mapped. Prosecutors must secure grand jury approval by demonstrating probable cause. Defense counsel will file motions to dismiss based on double jeopardy principles and selective prosecution precedents. Judges will scrutinize internal memos for any hint that partisan pressure outweighed evidentiary sufficiency. Press outlets will request disclosures under the Freedom of Information Act, and courts may compel limited releases if a strong public interest argument outweighs investigative secrecy. The process is standardized, but the public perception of fairness emerges from how faithfully each step follows the rulebook. Deviations, like suppressing exculpatory evidence or leaking prejudicial tidbits, erode legitimacy faster than any courtroom win can restore it. Meanwhile, the Epstein records saga rolls on. Should the promised files ever see daylight, they may well implicate figures across the political spectrum, proving once again that criminal behavior isn't confined to one ideology. The credibility of any revelation will rest on documentation, corroborating testimony, and careful vetting, precisely the safeguards that selective prosecutions sidestep. If names appear without context, speculation will run wild. If documentary trails are laid bare, the justice system can evaluate wrongdoing on its merits. That difference matters. Hyperbole may trend for a day, but evidence holds up in court and in the historical record. The coming months will test whether institutional safeguards, grand jury independence, judicial oversight, and a free press can withstand pressure to function as political props. No matter the outcome, one principle stands firm. Democracy is an ongoing negotiation between power that wants more and citizens who insist on limits. By staying informed, asking hard questions, and refusing to let complex stories be reduced to hashtags, each of us helps tilt the balance toward accountability. You've invested serious time in this deep dive, and that tells us you value journalism that chases the entire truth, not just the headline. Help us keep that standard alive. Hit subscribe so you never miss a breakdown. Click like if this analysis brought clarity, and drop a comment with your thoughts or questions. Algorithms notice active communities, but more importantly, we read every remark. Your feedback shapes our editorial priorities, steers future investigations, and fosters a conversation that extends well beyond today's video. Thanks for choosing News Decoded for a real look beneath the surface. We'll be right here, decoding the next story that deserves deeper scrutiny.